my question is, with a variety of theories of constitutional interpretation utilized in the judicial process, from the originalist to the developmentalist approach, how does the Supreme Court ensure that rulings are fair and uniform?
we count the votes.
No,
No, I mean, how do we ensure that it's fair and uniform? Look, we don't debate the things that my friend Justice Breyer and I have been talking about today. We don't debate them in conference. I mean, I'm not going to persuade him, and he's not going to persuade me. We've both thought about these things for a long time, and he will continue to apply his interpretation of the Constitution to the decision of a case, and I will continue to apply mine. And then you count the votes.
But it's not just that. I mean, it's partly. But you see, I don't start out with a particular view. I think you start out with a case. And we're trying to find the right answer to the case. And if I try to give some form or coherence to an approach that I have, it's only after looking at a lot of cases that I decided that I think that something arises out of that. And I don't think, and I think what Justice Scalia says, for example, about the problem of values coming into the opinion, the values of the judges, it's true that it's a problem. But we have a Constitution that was designed, particularly after the Civil War, to protect the individual rights of unpopular people. And think of Brown itself. If you'd gone back and looked totally at history, well, maybe they would have said schools at the time were segregated, and they passed the 13, 14, and 15 Amendment. But if we looked at the objective of the provision in the Constitution, which was to take people who had been formerly slaves, and they and their children and others would be just like everybody else, part of American society. And that was the objective of this. That was the dream. That was the hope. That's what they're trying to do. And in 1954, all you had to do was open your eyes and look. And anyone who opened his eyes and looked in the South would have said, and not just in the South either, would have said, this is completely contrary to what this thing is about.
And it was the same in 1878, or whatever the date was, when Plessy versus Ferguson was decided, which interpreted the text, and I start with text, which said that no state shall deny any of its citizens equal protection of the laws, said that you could require black citizens to require them to ride in a separate railroad car.
It was wrong.
It was wrong.
Fine.
And that relates to this other question. It was wrong when it was decided.
But it would have been particularly wrong if they'd seen what was going to happen.
One of my favorite sayings about the court, I don't want to encourage disrespect, but sometimes we get it wrong. I occupy the seat that used to be held by Robert Jackson, one of my favorite Supreme Court justices, and one of his was a concurrence or a dissent? I think it was a concurrence in a case. He wrote, "My brethren," in those days there were only men on the court. "My brethren sometimes forget that we are not the court of last resort because we are always right. We are always right because we are the court of last resort." And we've made mistakes, and we try not to, and I admire enormously the efforts of my colleagues to come out the right way by their lights, and I do by my lights. And
that's a very important.
I think we get it right, 95% of the time?
Yeah, we're unanimous, probably 20 to 30%.
And the other 5%, I'm right.
You're always right, except right when you said that. That is really worth underlining 7 times, because in reality, 5-4s are about 20 to 30% of the time. That's true. It's not always the same 5 and the same 4. And the way we approach the cases is we're trying to decide this case. And I love it when all the historical factors, the textual factors, the purposive factors, and look at the consequences, all lines up the same way, even if it's very close. But they're all lining up the same way, I think, great. And probably we will achieve agreement on that. And of course, if sometimes they don't all line up the same way, I say, well, we may not achieve agreement on this, but maybe we will. You never know. And we have a discussion about it, and we try to get to agreement, and then sometimes you don't get there. That's not because one side is obviously right or obviously wrong on any set of terms. And that happens over and over and over. So you have to keep that in mind when you read all these controversies. We're talking about the Border Patrol. The area between the borders is vast. That's where people make their democratic decisions. When you get to these boundaries, you have some cases that are so difficult. And he's brought up, Justice Scalia, about 2 or 3 of the most. And people have disagreements about that. There we are. And each approach has, I think, some problems with it. None is perfect, but there we are.
Don't think that because we have profound disagreements, I mean profound disagreements, and sometimes express them in what should I say, passionate language in dissents. Don't think that we are not a congenial group. Believe it or not, sometimes the press paints us as, you know, we're at each other's throats, nine scorpions in a bottle or something. You know, that's not the case at all. In fact, we're a very my best friend on the court is Ruth Bader Ginsburg, because I've been a colleague of hers since we were on the Court of Appeals together in 1982, and God knows Ruth Bader Ginsburg and I do not have the same judicial philosophy. But it has nothing to do with whether we're friends and respect each other and can conduct our business in a congenial fashion.
Yeah.
Basically, if you cannot disagree without taking it personally, you should look for another day job. You are not meant to be a judge.
And there's a deep reason for that. The document that you've read, the Constitution, says we're a nation under law. And that means we'll decide things through reason under law rather than fighting each other in the streets. I've never heard a voice raised in anger, really, in that conference room, or people making insulting remarks about each other. We resolve our differences where they are great, and sometimes they are, by listening and speaking in a reasonable way. And if I'm not going to convince somebody that way, I'm certainly not going to convince them by raising my voice. But that's the system the Constitution sets up, and I'm glad that it does. Thank you.